Hello, good morning. We're back again. We talked a little bit earlier about the estate. What is the estate? Your assets. What are your assets? And we named a couple of the assets. Do you remember that? Your home, your car, your jewelry, artwork, stocks, bonds, those type of things. We also let you know that an asset has value. We can place a dollar amount on it. And an asset can also be sentimental, something that you're passing down. Also, a liability can be a negative asset because it can be charged against your estate, which the estate is what? All of your assets. We wanted to talk right now about how to protect your assets, how to protect your estate. Your estate and your assets can be used simultaneously. So when someone says, I'm protecting my assets, that's I'm protecting my estate. I kind of wanted to give you guys a little overview at this point about trust. T-R-U-S-T-S, trust, which is the vehicle or the document, the legal document that will protect your assets, that will protect your estate. It's so important that we understand that we need to protect the things that we worked hard for. You worked so hard to buy a home. You worked so hard investing in stocks and bonds and keeping up to build your wealth. And when you build wealth, you want to be able to maintain it. And you also want to be able to pass it down to your beneficiaries so that they can maintain it and grow it. The best way to do it is putting it in a trust. I should say the best way and the only way to do it that all of us know about in our profession would be a trust. That's one of the main ways to protect yourself and your assets. If you know something different, then let me know because I haven't found anything yet. It's just a great tool. And it has to be done by a professional. You have these online trusts that you can put your assets in and then you end up in probate court. I would totally recommend an attorney, an estate planning attorney, that's all they do. And they will inform you and educate you on how you can protect your assets. But anyway, let's get into what a trust is. What is a trust? Trusts come into existence in a variety of ways. They can be created under a will, as in a testamentary trust. They can be prepared by an attorney, the only way I would do it. Or they can be created by a substituted judgment in a conservatorship. Yes, I've done that. But at that point, it's kind of too late. You're already in probate court. Remember, if your conservatorship is a court proceeding, so you're already in probate court. Okay, but first we must ask ourselves the question, what is a trust? Here it is. A trust is a way of owning assets. A person or institution such as a bank manages the assets held in the trust in a manner specified in the instrument, creating the trust for the benefit of someone else, the beneficiary. That's when you're passing it down to your children or whoever you deem important enough to leave your assets to. Hopefully someone you trust, someone you love and trust, to keep your legacy alive. How I look at a trust, you're speaking after incapacity, you're speaking after death, saying, I worked hard for all of this, and this is how I want it to go forward. So it's that instrument talking on how you see your life going forward after death. Isn't that cool? While you're gone, but you're still alive through the trust. Okay, trusts differ from conservatorships because you must obtain a court order to create a conservatorship. Yeah, we know that. The creation of a trust can usually be done with the help of an attorney with experience in probate. trust, and estate planning. Like I said, I wouldn't dare use an attorney that specializes in criminal law to put my trust together. They would have to have experience in probate, trust, and estate planning, especially trust and estate planning. But they should know all three. A trust, it is a document which describes what you're going to do with the income beneficiary. We're going to talk about the beneficiary in a minute. It proves various powers and instructions to the trustee to assist in the fulfillment of trust duties and responsibility. It provides information and direction to the trustee and acts required upon the death of the trustor. So we just mentioned a beneficiary. That's the person listed in the trust to actually benefit from the assets in the trust or from the estate. So that's the beneficiary. That's the person who's going to benefit. Beneficiary is the benefactor, the one who's benefiting. Then we have the trustor. The trustor is the person who actually owns those assets. That is their wealth, that's their estate. They're the one creating the trust. It's the trustor. The trustee is the person who is going to be charged with distributing the trust assets at the time of death. More likely it's death. Sometimes it's incapacity before a new trustee steps in. But I don't want to get you confused, and I don't want you to get me confused. But the trustee is the person who actually steps in and manages the trust. So I'm a trustee of several trusts. So and the person doesn't have to actually pass away for me to be trustee. I'm listed as a fiduciary trustee, where I would step in to help them manage their real estate. I do that. To help them manage their investments. I do that. So that's what a trustee does. And also, of course, after death, they step in and then they handle the whole thing. But the trustor, the creator of the trust, is very important because they're the ones who actually owns the assets. This is their hard work. This is what they've done. So the trustor, the person that created the trust, can also be the trustee during their life. So they have the ability to change the trust while they're alive. And then once they're gone, the trust becomes irrevocable. So you have a revocable trust. See all of these new words? It can become complicated. But as we talk and go through all of the process and procedures, you'll start to understand how everything ties together. And also write it down. Have a pencil and paper while we're talking. And if you have any questions, leave them in the comment section. I would more than be happy to answer all of the questions. But anyways, let's get back to the topic of trust or the trust document, because we can get confused saying trust. Yeah, I trust you, but we're talking about a trust document, which is a legal document and is a private document. That's one of the difference between conservatorships and trust. One of the difference. But the biggest difference is trusts are private and they keep you out of the probate court. That's where we don't want to deal because a lot of our money gets eaten up. Okay, so we talked about trust. Now, of course, if I'm going a little too fast, sometimes I do, go a little too fast. Write down the questions or put them in the comment section. Okay, so I think we were talking a little bit about, the trust, the trustee. And The trustee is the person like me, a fiduciary. We're certified, and I'm certified and licensed. But as a fiduciary, you have the ability to manage trust. That's one of the responsibilities you can take on. Like I said, you can focus on conservatorships if you're a fiduciary. You can focus only on trust, or you can focus on trust and conservatorships and managing the estates, which I love to do all of them. I'm so diversified. Isn't that great? But a trust is so important because we know that it's a way of protecting your assets, protecting your estate. What do you mean by protecting your assets and protecting your estates? We'll get into that in a little bit, but let's talk about some of the reasons people actually establish a trust. Trusts are established for many reasons, and typically when they are established, it is for more than one reason. The list below contains common reasons for establishing a trust. Here are some of the reasons people establish trust. Privacy of administration. The laws related to privacy have changed. Your accounting and confidential communication between trustee and available successor trustee, they remain confidential. You avoid probate and related expenses. Potential to avoid conservatorship proceedings. Get help during one's lifetimes. Conservatorships take a long time to establish, but if you have a trust and you become incapacitated, I thought I had it on vibrate. If you have a trust and you become incapacitated, all of your wishes are already written down in the trust, so you don't have to be conserved. You have a trust, and the trustee steps in and starts administering that trust. And there's so many components to a trust. We can't get into it into this video. We're already almost 12 minutes in, and I know the attention span. If your attention span is like mine, you're like, okay, get to the point. I think I have already, and we're going to get to more points. Okay, so you can get help during your lifetime, establish routine during one's lifetime, provide heirs with notice that someone has authority, meaning in your trust, they will know, meaning your beneficiaries, that you have a fiduciary or whoever you put in charge as the trustee. It's a setup mechanism to pass assets on to beneficiaries, and it creates a vehicle. This one is kind of important, to take care of less responsible heirs. For instance, if you have children with special needs like autism or a different kind of developmental disabilities, you set up a special needs trust to make sure that they're taken care of in the case that something happens to you. So trusts are very important. It's not only to protect your assets, it's a way of passing down the assets. It helps with tax liabilities. There's so many things, but I definitely would recommend an attorney and a seminar to go into all of the intricacies because it's so much. But we do know a trust is a way of actually protecting your assets, and we know that assets is a part of your estate, and your estate are your assets. Though that's all the things that you own, things that you've worked hard for, things that are important to you, things that are valuable, your money, your hard-earned income, your hard-earned beautiful trinket that you got from vacation, sentimental value, letters passed down from family, friends, all of those are sentimental and they have a value to you. The trust has to be funded with all of your assets. Now we're onto something different. So once you have a trust established, it's established for the purpose of funding. So you have a trust, you have to fund the trust with your assets. Isn't that interesting? Let me give you one story, then we're going to finish this video up because we're, oh wow, 15 minutes. I didn't know I could talk so much. Really, I didn't. But think about this, seriously. Michael Jackson, oh my God, love him so much. When he passed away, they said he had a trust, right? But they said his trust was not funded. So everybody's saying, what does that mean? He had a trust, but it wasn't funded. So what that means is they're saying that the assets, his estate, was not put into the trust. It was not named. So when you have a trust document, all of those assets have to be funded into the trust. You have to name them. You have a trust document, but if nothing's in the trust, it's not funded. It's of no value. Isn't that interesting? I'm not sure if I believe that or not because he was so brilliant, but that's the story. We're going to end with that, and when we come back, we're going to talk a little bit more about trust. So the next couple of videos are going to be about trust. Hopefully they won't be, oh my God, 15 minutes. Thank you so much for listening. Leave all your comments in the comment section, and I hope you learned a little bit more about protection of your assets, protection of your estate during this video. Leave your comments in the comment section. Thank you again for listening, and when we come back, we're going to continue the conversation. Peace and greetings to all.